What happens to your earnest money if you put it down in good faith and the seller backs out? In many cases, buyers may get their deposit back. But here's what many buyers miss. What your contract specifies about seller default affects more than just your refund amount. It also determines what other options you may have. With homes sitting an average of 35 to 55 days and a sold-to-list ratio around 92%, sellers can no longer count on a quick replacement buyer. That shift means buyers who put down earnest money in good faith may have greater negotiating leverage, but only if they understand what their contract actually says about default and remedies. The standard TREC 1 to 4 family residential contract includes a default provision called paragraph 15. If a seller fails to comply with the contract, the buyer has two paths. Path 1, terminate the contract and recover the earnest money as liquidated damages. That's the faster, cleaner option. Path 2, pursue specific performance. This is a legal claim asking a court to require the seller to complete the sale. Texas courts may order specific performance when a property is unique, and monetary damages aren't enough to make the buyer whole. This tends to be a longer option. These two paths are generally mutually exclusive, meaning a buyer will typically need to choose one or the other. When earnest money is disputed, the title company cannot decide on its own who should receive the funds. Generally, the title company will need either a mutual release signed by both the buyer and seller or a court order explaining how the money should be distributed. If the parties cannot agree, either side may send a written demand for the earnest money to the escrow agent. Once that demand is made, the other party has 15 days to submit a written objection. If no objection is received, the escrow agent may release the funds to the party who made the demand. But if the other party objects, the earnest money will typically remain in escrow until the parties reach an agreement or a court resolves the dispute. That is why understanding the process and responding quickly can matter when earnest money is at stake. To illustrate how this plays out in practice, consider a buyer in Texas who is under contract on a home listed for 47 days. After the option period expires, the seller receives a higher all-cash offer and refuses to close. The buyer has already paid for an inspection, an appraisal, and a mortgage rate lock. The earnest money is held by the title company, and the seller is refusing to sign a mutual release. In this situation, the buyer's options, whether to make a written demand under paragraph 18, pursue specific performance, or evaluate other remedies, depend on what the contract says and the specific facts involved. A Texas real estate attorney may help evaluate which path is appropriate based on those terms.